Hey, India had improved the ranking in ease of doing business for the past several years, and one of the major reasons for that escalation is none other than introduction of the Insolvency and Bankruptcy Code. So, what is meant by insolvency and bankruptcy, and what are the implications of it? What are the reasons for introduction of that new law into the Indian economic regime? All those things I would like to share with you in my next few videos. So, there is a law which is enacted by the Parliament of India, which is named as Insolvency and Bankruptcy Code 2016. To understand those acts better, it is good to identify and understand the basic terminologies involved in the name of the act itself, insolvency and bankruptcy. So, what is called an insolvency? Insolvency is nothing other than inability of a person or a corporate person to pay its bills or dues. And these dues, and not only the inability to pay its dues and debts, it is actually they are unable to pay and it is becoming a default. That is also a reason for the insolvency. And bankruptcy is nothing other than a person is declared as a bankrupt due to his incapability to pay his dues, as and when it become due and payable. There is another terminology also which is connected with these two terms, which is called liquidation. Liquidation is basically a process of winding up of an incorporated entity or a corporate person through a legal process under the code. So we know that when a company or individual or a partnership firm is facing the insolvency, the normal parlance is that such persons will become left alone in the society with no help extended to them. That was the condition up to the introduction of the Insolvency and Bankruptcy Code 2016. But now, with the introduction of this new code, a change has happened is that there is something to assist these ailing companies from this present situation, hand-holding them and uplifting from their issues and problems which is connected with their due and defaults. So, before going into the basics of the insolvency, we need to review the basic legislative history of insolvency regime or the default regime in India. So, up to 1993, if the banks or financial institutions would like to recover their dues, they have to follow the normal civil procedure code and approach the courts under an act called Recovery of Dues to the Banks and Financial Institutions Act 1882. As we all are aware, when a bank is approaching courts for recovery of their money, it will spur up a lot of litigations and result in a huge delay to recover the money which is extended to the companies or creditors or persons. Due to the lacuna faced by the financial institutions and the struggles they had faced in the courts of law, understanding that particular scenario, the government of India had promulgated an act in 1993 called Recovery of Debts due to the Banks and Financial Institutions Act 1993. But unfortunately, due to the poor infrastructure or lack of adequate forums to properly adjudicate on the matters, that act also had failed to resolve that particular issue faced by the banks to recover their money. So, in the light of recommendations of a committee called the Tiwari Committee, the government of India had constituted special tribunals, which is called debt recovery tribunals, under these provisions of this 1993 Act. Even then, even with the introduction of these new tribunals, there was a continuing rise in the number of non-performing assets, NPAs, and of the banks and other financial institutions of India, which had resulted in a constitution of another committee called Narasimham Committee 1 and 2, and another committee called Andrajuna Committee, which was constituted to identify solutions for these particular issues. Resultant to the findings of this committee, a new act has got introduced called SARFAESI, Securitization and Reconstruction of the Financial Assets and Enforcement of Security Interest Act 2002 has got promulgated and implemented. But even with the introduction of that particular law, SARFAESI, the debts of the banks actually spurred up, and by 2014-15, it has reached the peak and it has started affecting the financial health of most of the banks in India. And when the new Modi government came into picture in 2013, they started actually brushing up whatever the steps they had taken before to resolve this issue and tighten the bank defaulters. And banks were asked to classify many of the standard assets as non-performing assets. And in 2015 June, Reserve Bank of India had published a list of 12 companies which were actually holding 25% of the non-performing assets of the country. And those 12 companies were named as dirty dozens by the RBI, which includes very famous companies like Bhushan Steel, Landco, SR Steel, Alog Industries, Amtech Auto, Monite Ispat Limited, Electro Steel, IRA Engineering Services, JP Infratech, ABG Shipyard, Jyoti Structures, etc. These are the 12 dirty dozen companies. And identification of these companies had actually resulted in the promulgation of the new legislation called Insolvency and Bankruptcy, called or IBC. So it is a tailor-made code for the resolution of the bank debts or bad loans. This code was passed by the Lok Sabha and got the President notes in May 2016, and on May 2017, RBI got vested with the powers to initiate proceedings to recover these bad loans from India. Once this act was promulgated and RBI had got power to implement it, RBI immediately swung into action and released this the list of this dirty dozen companies. And further to that, rest is history. Many insolvency resolution cases have been filed, many has been resolved, and many companies actually still facing liquidation and resolution. So at this point of time, we need to just have a relook into the words of wisdom of the Goswami Committee, which was in 2019, their 1993 report, which very clearly stated that there are sick companies, there are sick banks, ailing financial institutions and unpaid workers, but there are hardly any sick promoters. There lies the heart of the matter. This was a statement in the 1993 that Goswami Committee report. What was shedding light on the fact is that though the companies are going sick and that unable to pay their debts, the promoters continue to be in divine control of those companies and enjoy all the benefits of the corporates. But in the IBC regime, that has been reversed, and that is the major difference between the previous legislations and the IBC. So if you see the corporate insolvency regime in India, what are the laws which are actually covered in the insolvency is that one is Companies Act 1956 was there. Then is Sick Industrial Companies Special Provisions Act 1993 was there. Recovery of the debt to the bank and Financial Institutions Act was there. SARFAESI Act 2002 is there, and Companies Act 2013, and finally Insolvency and Bankruptcy Code 2016. These are the legislations which are actually governing the corporate insolvency resolution or regime in India. When it comes to individual insolvency regime in India, there are basically three acts. One is called Presidential Town Insolvency Act 1909, Provincial Insolvency Act 1920, and Partnership Act 1932. These are the three acts which are governing individual insolvency. So all these reforms, introduction of the new IBC came into based on a report of the Bankruptcy Law Reforms Committee, which was formed in 2014, August 22nd, under the chairmanship of Dr. T.K. Vishwanathan, who had submitted his report in November 2015. The rationale behind this BLRC committee was that to identify the difficulties of the earlier regime, requirements of an unified law dealing with IBC. As I had mentioned before, there are multiple laws which are actually trying to resolve corporate insolvency as well as individual insolvency, to do away with that multiple laws and bring in a unified or combined law to resolve this. And when a default comes in, what is to be done? That is another factor which was the main contention, main issue before this committee, because there are two legislations. One is SARFAESI, otherwise the Recovery of the Debts to the Banks Act, basically in favor of the creditors, whereas SICA was basically in favor of the ailing or sick companies. So what is to be done when default occurs was a question which was to be addressed by the BLRC. Then strategy proposed by this committee was to initiate a resolution process for a period of 180 days. And through a resolution professional who shall have substantial powers of the management. We know that if you see the previous regime, for winding up a company, it was taking average of 4.5 years. And there are certain companies which are not even wound up for a 35 years time period of the process. From that long, lengthy time period, the IBC was proposed to shrink it to around 180 days time period. That was the rationale while considering this particular legislation by the BLRC. And this particular strength, that particular proposal put in by the BLRC had multiple strengths. One was that it will prevent, that particular legislation is intended to prevent asset stripping by the promoters. You know that whenever a company is into the problem, the first person who is coming to know about that issue will be none other than the promoters. So instead of saving the company, what the promoters will normally do is that they will start taking the whatever the possible assets to their name, like in a fraudulent transaction. It is called asset stripping. The IBC was basically meant to avoid that kind of asset stripping by putting a person called a resolution professional into the place of the promoters, and that particular person is proposed to operate the project for the rest of the period till the issue is resolved. And the promoters and others can also make a proposal for the revival of the company or a resolution. As the name suggests, insolvency and bankruptcy code is basically to resolve the debt through the help of a committee and as well as a professional called resolution professional and committee of creditors. And if this attempts fails to resolve the company and revive the company fails, the resolution will considered as failed and finally it will go into liquidation or bankruptcy. So it is actually, this particular code also includes a provision for bankruptcy or resolution of the bankruptcy of the individuals also. So under this code, speed is considered as the essence for the recovery mechanism, and unlike the previous legislations, the law had put in a very stringent timelines for the completion of the process. And the other major issue before the BLRC was to identify the reasons for this delay, and it also identified a need for a separate regulator for this insolvency resolution regime. And we know that there are multiple reasons for the business failure or a financial failure or leading to the insolvency. One is that definitely the financial failure. Second will be the business failure. And third and most important are the fraudulent operation. These are the basic steps. And the BLRC had suggested steps for assessment of the viability of the project, sidestepping of the promoters from the project which is facing insolvency. And it is also intended to reduce the debtor-creditor conflicts and bring in a mechanism for better negotiations. So these are the basic things which is actually to be considered or to be understood to understand the particular IBC law better. So in the next video, I will be taking you more through the provisions of the IBC. Thank you very much.